Good morning, everyone, and welcome to September's Risk Reduction Risk Management class, where today we're going to talk about some common questions and problems that our agents, not only within RE/MAX Connections, but frankly, the entire real estate agent community in California struggle with. I talk to Car Legal pretty regularly, and I monitor a little bit the kinds of questions they're getting to see if, how that relates to the kinds of questions I'm getting. And what I'm going to be talking about is pretty universally challenging from time to time for various agents. So we're going to talk about them. If you're aware of some of this stuff, then bear with us as we go through it. Like I said, hopefully, you will gain greater insight into some of these problems and transactional issues that come up that cause you to lose your focus on income producing activity and having to deal with the problems that you encounter. So let's get right into the presentation. Let me share my screen. And hopefully everyone can see my screen now. And let me go right to.
We can see it.
Does everyone see it okay?
Yep, we can see
All right. Okay, so as always, if you have any problems or questions, call me. You can call me at the office during business hours. That's best. My direct line, which is working real well, is 858-201-7115. That rings at my desk. Leave a voicemail. If I don't answer, it'll be because I'm probably on another line, and but I will return the call. If it's after hours, or you can email me, of course, at any time. If it's after hours and you want to call me, by all means, call me on my cell. It's best to text me, and then I'll respond because I see the text almost as quickly as they come in. My voicemails, sometimes I go an hour or so, maybe even a couple of hours on weekends without really listening to my voicemail, but I do check it pretty regularly. So I like to pride myself on a couple of things. One is, and nobody bats 1,000, but if you call me, I want to return that call before the end of the day, unless your message is, call me tomorrow. Well, then I'll probably take advantage of that. And then the other thing is, if you're working, I believe I should be available. So never apologize or be reluctant to call me in the evening or weekends. I'm happy to help. What you do drives this company. So if you're having a problem with a transaction, that's a company problem. And I want to be available to help you. Okay. So let's get into some common questions and problems in real estate transactions. This is a collection of some of the most common questions I get and some of the most common problems I deal with. It's not all of them, but it's these rank pretty high, and I want to go through them and help you approach your transactions with a little less stress. So we're going to talk about the delivery of disclosures. We're going to talk about the FHDS that continues to be a major source of confusion. We're going to talk about insurance claims. I've had some problems in the past, and we've had a couple of issues even recently. So I want to be sure everybody is tuned up on how to disclose insurance claims. And if you're the buyer's agent, what you should do when insurance claims are disclosed to you. We're going to talk about making affirmative statements. That is always an inadvertent problem agents get themselves into. There's probably not a month that doesn't go by that I'm dealing with a problem that's exacerbated a bit by an affirmative statement that the agent made or a question that the agent answered. And you can, if you're not careful, your statements and your answers can bite you. So I want to talk about that. I'm going to talk about 4 advisories that I want everyone to be aware of. The Scripps Ranch, Escondido, and Fallbrook agents have seen these for quite a while. Carlsbad and Rancho Bernardo, these may be new to you, and I want to bring these to your attention. They are very, very helpful in dealing with issues that come up later in a transaction. And finally, another biggie, selling tenant occupied properties and how to deal with that and how to stay out of trouble when you are selling tenant occupied properties. All right, let's get right into it. The timely delivery of disclosures. The time frames is specified in 3N3. The boilerplate is 7 days after acceptance, especially if you're a buyer's agent. If you are agreeing to a short escrow period, you should also shorten the seller's delivery of documents. I've actually seen more than a few times. And by the way, short escrows are problematic by themselves. Doesn't mean you can't do them. And sometimes it's in your client's best interest to do them. But I've seen many times a 10-day escrow, and yet the seller has 7 days to deliver documents. That's really not practical, to serve the buyer well. So if you're going to shorten an escrow by half, you want to shorten this time period by half at the very minimum. Okay, so the boilerplate is 7 days, and that's assuming a typical 30-day transaction. Time periods. Paragraph 14 of the RPA talks about time periods, and the seller delivers documents specified in the 3N1 that we just looked at, and they deliver to the buyer all reports, disclosures, and information for which the seller is responsible. Folks, this includes the termite report, by the way. So you should be proactive about getting that termite report out right away. The same with the septic report, although as a practice, everyone seems to work pretty well with the septic report being done toward the end of the transaction, because it's rather expensive, $600, $700, $800 to do a septic report, and they don't last long. So if you do one and then the buyer bails because he doesn't like his physical inspection and you've already done the septic, and then it takes you 2 months to get it back into escrow, that report might not be accepted by the other side or by the lender. So septic is the exception to, and again, it's more of a custom than contractually forgiven, but it's often done later in the transaction. And then, of course, the things that a seller is responsible to deliver are specified in the paragraphs 9B, 6, 10, 11, a lot 11 and 13. And I'm going to talk a little bit about some of those. 9B is leased and lien items. That's if you have solar panels, if you're leasing solar panels, that needs to be provided early on. 10 is inspection reports that the seller's already gotten, mostly as a result of government compliance issues. That doesn't occur a lot in San Diego. It does happen in LA. The paragraph 11 is the statutory disclosures, A, B, C, and D. 11H is FERPTA. K is HOA docs. By the way, HOA docs are not a statutory disclosure. And I'm going to talk about that in a minute. And that's a problem that sometimes agents get into. And then finally, 13A and D. 13A is the preliminary title, and 13D is any material facts that a seller should disclose. So that it gives you a pretty good list of what you want to get out. And again, you want to get all that out in 7 days. Okay, so that's where the statutory disclosures are listed. It's 11A, B, C, and D. So 11A talks about a few things, but principally about the TDS and the NHD. It also mentions some things that are found in the title report, like mellow roofs. That's a statutory disclosure. It ends by talking about some of the stuff disclosed as a result of fire hardening, FHDS. Okay. Lead disclosures is a statutory disclosure. Like I said, the home fire hardening and the defensible space are all statutory disclosures. What does statutory disclosures mean? It means that it's contained in Civil Code 1102, and it carries, the most important thing is it carries an unwaivable absolute right of rescission by the buyer, regardless of the status of the transaction. I'm going to talk about that a little bit more in a minute. So those 11A, B, C, and D, very important to get those out quickly, because the buyer has 5 days after receiving them, regardless of when they were delivered, at a minimum. They also have the contingency period. So if they get them right away, the 5 days doesn't matter. But if they get them late in the transaction, it automatically reinstates their ability to cancel, even if they've removed all contingencies. So those are important to get out right away. So 14B talks about if any report or disclosure that the seller is responsible is not delivered within the time frame specified in 3N. So you took longer than 7 days. The buyer has 5 days after delivery of those reports, or what's contained in the time periods in 3L, which is the contingency time periods, to deliver a removal of contingency or to cancel the agreement. So if you're late in delivery, that 5 days could extend their contingency period. Now, for a non-statutory disclosure, and the most common one that agents and sometimes get themselves in trouble with is HOA docs. HOA docs is not a statutory disclosure. Neither is most of the preliminary title report. So if a buyer removes a contingency relative to a disclosure that is not statutory, when the report is delivered, the contingency is not reinstated. So if a buyer removes his HOA docs contingency and then a week later gets the HOA docs and finds something he doesn't like, that can be too bad for the buyer, because that will not reinstate his contingency period. Now, the exception, of course, is those disclosures, discussed in 11G in the determination rights for statutory disclosures, and I've already kind of covered that. Anytime a statutory disclosure is delivered, you automatically have a minimum 5-day right of rescission. You could have a longer right if you had a longer contingency period, like I said. So you deliver a TDS on the 3rd day of a 17-day contingency period. Well, you've got the balance of the 17 days. If you deliver the TDS on the 15th day of a 17-day contingency, you've got 5 days after delivery, which would extend that contingency period an additional 3 days. Hope everyone's following along. I'm not confusing you with that. Okay, now the transfer disclosure statement. This is still a little bit of a problem. It's getting better, and hopefully the TCs are catching this. For all the TCs that are on this call, you're doing your clients a great favor when you, number one, tell the seller you haven't completed the TDS, and so the delivery is not effective until it is complete. So the transfer disclosure statement must be fully completed in sections 1, 2, and 3. So if the seller has completed section 1, which is the substituted disclosures, most common box to check is no substituted disclosures, but one of those boxes on the TDS has to be checked in box 1. If section 1 is all blank, then the TDS has not been delivered. And then the seller has to complete and answer all questions in the seller's information section, which is section 2. From time to time, we still see TDSs where sellers are skipping some of the questions, and if they do, they have not answered the question. By the way, a yes answer requires an explanation. So they check yes, but they don't put any explanation down on those blanks at the bottom of section 2. They have not completed the TDS. And again, the problem is then delivery hasn't occurred. And when it does get corrected, that's when the 5-day right of rescission happens. And then finally, the seller's agent must complete their agent's inspection section. Now, there's 2 ways to do it at Remax Connections, and most brokerages require an AVID. So if the box in section 3 of the TDS is checked, see attached AVID, then the delivery of the TDS has not occurred until the agent gives the AVID. Now, if they don't check the box and they write something on those blanks, then they have done their AV, agent's visual inspection rather, and they don't have to do the AVID. We require it, and most brokerages do require it. All right. So now, now there's also supplemental disclosures that are also in the civil code that must be answered, and some of those are also statutory. Not all of them, but some of them are. So unless the seller is exempt from a TDS, then the contract requires an SPQ to be provided, and must answer, again, all the questions and then sign the document and deliver it to the buyer. So you're all familiar with the SPQ, and those questions are in paragraph 6. Some of those questions are statutory questions, things like illegal substance being controlled and an illegal substance being released on the property, and whether it's adjacent to an industrial zone or a military ordinance zone. That is a statutory question, and until those questions are answered, the buyer has 5 days after those questions are answered to rescind the contract if they choose. So just as important getting the TDS out quickly, also, unless you're exempt from the TDS, get the SPQ out quickly. Now, the contract requires the SPQ. Now, if you're exempt from the TDS, then, and this is something that a lot of agents are skipping, and they should not. That's problematic if there's later a problem. And again, absent doing this, what I'm about to talk about, you haven't completed all of the statutory required disclosures. And so you're giving the buyer an unlimited right to cancel, time period to cancel, because you have not provided the ESD. You have an exempt seller from a TDS, so then the ESD must be provided. Why? Because, and answer all those questions, because the ESD also contains some statutory required questions. Not all of them, but some of them are. Again, is it, has an illegal substance been released on the property? Is it in an industrial use zone? Is there military ordinance adjacent to the property? See, those have to be answered, or you haven't, the seller has not fulfilled their statutory duties to disclosures. And until they do, by the way, it's not waivable. And until they do, the buyer retains an unlimited right to cancel. In other words, it's one of the things, if a buyer cancels because he doesn't like something in the physical inspection report, there is a principle, it's not utilized too much, but there is a principle that the buyer has to act in good faith. So if the buyer cancels and not acting in good faith, and you could prove that, by the way, it's pretty hard to prove, but if you could prove it, the buyer wouldn't have the right to cancel, even though something was disclosed to him, but he's not acting in good faith. I don't want to get in the weeds too much and talk about it. I want to make this point. Canceling pursuant to a statutory disclosure does not require acting in good faith. It's an unlimited universal right. That's why I keep saying that. So all they have to do is say, sorry, canceling because you didn't tell me whether it's an industrial use zone or not. It's not, well, you didn't tell me. And so I get to cancel because you didn't answer that question. And believe it or not, the buyer would get to cancel, even though it's not. Okay, so these questions, some of these questions in the ESD or the SPQ, very critical to get out. All right. That ends the timely delivery of the disclosures. I want to make one other comment. Don't have a slide for it. I meant to make one. I forgot. As a buyer's agent, you should ensure that you got the TDS and the SPQ delivered to you prior to your physical inspection. I can't tell you how many problems have occurred because something was disclosed in the TDS that the inspector didn't look at. And had the inspector known about it, the buyer could have said to the inspector, check this. Or even more to the point, if the inspector is given the TDS, I would argue the inspector has an obligation to go through it quickly and see if there's anything in there he or she should be focusing on. Sometimes when we want to bring the inspector into the solution to something that wasn't properly disclosed or discovered by an inspector when it should have been, the fact that the inspector never saw the TDS or SBQ helps protect the inspector from liability. I've actually been in court cases where the participants made it a point about whether or not the disclosures were available to the buyer prior to the buyer conducting their physical inspection, with the statement being if they weren't, that was a problem for the seller. So, and for the buyer's agent, quite frankly, because we have a duty to help and protect our buyers. So again, as a buyer's agent, make sure you get the TDS and SBQ and have them with you when you meet the physical inspector, and provide them to the inspector and advise the buyer to review these. And if you have any questions, bring these questions up with your inspector at the physical inspection. Okay, let's talk about the fire hardening and defensible space disclosure addendum, FHDS. Here's what I can tell you. Everybody's confused by it, so don't feel bad when you have a question. I honestly can tell you two things. One, you can do something about, and the other, you can't. The one thing is I can tell you is the more I review this, the simpler it gets for me. And I'm not that smart, folks. I'm not any smarter than most of you on the call. I think I'm smarter than a couple of you. I won't name any names, but most of you are probably smarter than me. So the more you go through this, the more you'll begin to get it, because it really is pretty straightforward. Now, the other problem is, and this is big, car legal recognizes this, but there's not much they can do about it. Most government authorities are misquoting the law. And they're misquoting the law in a very gross way. They are stating that to sell your house, you have to have a defensible space inspection. And many of them are saying, and you have to bring it into compliance. With the exception of two areas, that is absolutely yet not true. And I've had discussions most recently. I've had pretty good successful discussions with the other side when they insist we have to do it because they checked with CAL FIRE, and of course CAL FIRE will tell you you have to do it. You do not in San Diego County. But usually when I have a discussion with the other side, they get it. They understand. I go through it in pretty good detail. Somebody accused me one time of getting into the weeds a lot. I like to think I stay out of the weeds, but I probably do get into the weeds. So they get it. I can tell you that a few people have pushed back. Why? Because no, we went to a seminar and Cal Legal was there, and some attorneys were there, and the Association of Realtors was there, and the city attorney was there, and they all said, no, you have to have an inspection. You do not. So the point I'm making here is it is easy to be confused because there's so much misinformation being put out there by people who I say should know better. And Car Legal is aware of it. They're trying to get CAL FIRE to correct their website. Right now, if you go to CAL FIRE, they're going to tell you need an inspection to sell your house. If you go to their website, you go to the San Diego website, they're going to tell you need an inspection to sell your house. You do not yet. And why? Because there's no local point of sale ordinance. That's why. Okay, so let's talk about the FHDS. I think I skipped something there, did I? No, I guess I didn't. Oh, okay. Yeah, the delivery of the FHDS is contained in paragraph C and D of 11C and D of the RPA. Okay, the fire hardening defensible space addendum. There are 3 sections. I'm going to go through them real quickly and answer all your questions, hopefully, because it is pretty straightforward. You have to deal with misinformation. By all means, many of you have called me to confirm what you should do, and I volunteered, and I'm happy to do it. And generally, it goes well. I'll talk to the other side who is insisting, no, you have to do something other than provide this disclosure and addendum. And I'm happy to talk to the other side, and I'm generally pretty successful. They come away with a little better understanding of the law. Okay, now I'm not smarter than anybody. I just have more time to do this. You guys are out there working hard helping buyers and helping sellers. And we want you to do that because that's how we survive. So I take no special credit for understanding this form real well. I get to spend a lot of time poring over laws and all that kind of stuff when you're out, doing, finding sellers, finding buyers, and going through your transactions. Okay. So the paragraph 1 simply talks about the law. And the thing you want to be aware of is, when do you give the FHDS? So, it's contained here in paragraph 1. If the property is 1 to 4 units, then an FHDS might be required. If it's more than 4 units or land, then it doesn't matter where it's located. It can be located in the very high fire zone, but it's raw land, no FHDS is required. Only for properties containing 1 to 4 units. The second point is, a seller is not exempt from a TDS. In other words, the seller must provide a TDS. Well, then he also, or she must also, provide an FHDS. So successor trustees are exempt. Probates are exempt. So if you're exempt from a TDS, you're also exempt from the FHDS. And then finally, the property is located in a high or very high fire zone. And I'm going to talk a little bit about that in a moment. Well, maybe I'll talk about it now. The problem with identifying whether it's in a high or very high fire zone is the law and the natural hazard companies don't quite match up yet. And so they're changing it a little bit. The natural hazard companies that are affiliated with CAR now put on the front page, on the disclosure page in front, whether the property's in a high or very high fire zone. But often what they do is they do say if it's in a very high fire zone, that's good. And then they say it's in a wildland area. And that's where the little bit of the problem exists, because the civil code doesn't recognize wildland fire hazard zones as being required to do an FHDS. Now, wildland fire areas are composed of 2 areas. One is moderate and the other is high. So if it's in a wildland fire area, you have to go into the report a little bit and determine, is it a moderate fire hazard zone? And if it is, an FHDS is not required. If it's in a high, which is also part of the wild land area fire risk zone, if it's high, yes, an FHDS is required. So if it's not in a very high, but is in a wild land area, fire area, you do have to look within the report to see if it's a moderate, no FHDS required, or high, FHDS required. Okay, and then finally, it's a small point, really. It's pretty simple to answer the questions in section 2, paragraph 2. But for fire hardening, if the property was built after January 1, 2010 or after, then technically the seller does not have to complete paragraph 2 of the FHDS. The FHDS addresses 2 laws, the fire hardening laws and the defensible space laws. The fire hardening laws state that for properties built January 1, 2010 or later, no fire hardening disclosure is required. They can make one if, it's not a bad thing to do, but that's something you should be aware of, perhaps. Okay, so paragraph 2, this is where it contains the statutory notice required by the code and then the fire hardening vulnerabilities. And like I said, for properties built prior to January 1, 2010, the seller must answer to the best of their knowledge. Are they aware of? And if they're not aware, the answer is no, obviously. So if they're aware of the fact that they have eaves, soffits, or roof ventilations with openings in excess of 1/8 of an inch that are not flame or ember resistant, if they're aware of that, then they would check yes. If they're not aware of that, and most sellers, I'm going to say, are not aware of that, there's only a couple of questions that a seller is probably aware of. One would be perhaps the roof covering. The other might be single pane. The other might be rain gutters without covers. They might be aware of that. And so, but they answer these yes or no, depending on what they're aware of. Nobody has too much trouble with that. The problem that occurs with the FHDS is in paragraph 3. So in paragraph 3, there's a couple of things to be aware of. First of all, is the property affected by local vegetation management ordinance? In San Diego County, the answer is yes. So any property that you're going to sell in San Diego County, because San Diego County has a vegetation management ordinance. Some of the cities may not. I would suspect. I don't know if Coronado does or not. I was thinking about that, but it doesn't matter because it's in San Diego County, and San Diego County does. So is there a local vegetation management ordinance in effect? Yes. So if you're giving an FHDS in San Diego County, you should check is. It is subject to a local vegetation management ordinance. Now, here's the big thing. I'll make this point. I've kind of made it in different ways already. The local vegetation management ordinances, both the cities, some of the cities have them, the county has them. They talk about managing vegetation. They do not talk about getting inspections, and they certainly don't talk about a point of sale inspection. So AB 38 that talks about when you sell your house, you have to get an inspection and you may have to bring your property into compliance is true if there is a local ordinance that requires it. Absent a local ordinance that requires an inspection and is specifically a point of sale inspection, you do not have to have it inspected. So as a matter of selling it, let me add that. Okay, so property is subject to local vegetation, and I always make this example. I'm not selling my house, but I'm subject to local vegetation management because I'm in a very high fire zone, and I've got to make sure that the grounds around my house. I don't have that many grounds. I'm in a little, actually tiny little suburban lot, but there is a slope, and the slope's got to have all the brush cleared, and my firewood needs to be away from the house, and I'm supposed to have non-combustible plants, within, any house plant within 5 feet of my house is supposed to be non-combustible, and that kind of stuff. So we are subject to local vegetation management, doesn't mean we have to get an inspection. Okay, now paragraph B is the seller aware of or not whether the property is in compliance? I would argue that that's why it's default. Most sellers don't know because they haven't had an inspection. So they don't know. So the default will work. The seller's not aware whether he's in compliance or not. I'm only aware of it because, number one, I studied the law, and number two, my insurance agent company got after me. But most sellers may not be aware of the local vegetation management ordinance. Some of them know it exists. Some don't even know it exists, but they don't know all the different points. So, but the default then is the seller's not aware. If the seller is aware, then the property, he's aware because the property has been inspected and he is in compliance. He had a property inspected and he's in compliance. So the report will say that. So then you would check box 2, or he is aware and his property is not in compliance, and he knows that. Why? Because he had the property inspected and he got, a couple of things noted that he's got to fix to bring his property in compliance. Then he is not in compliance and he's aware of that. So 2 or 3 is only going to be checked if the seller actually has a fire inspection report. And if they don't have one, then the default 1 is going to apply, and that's usually the case. And then finally, C is contained on the bottom of page 1. The first one is on the bottom of page 1, and then starting at the top of page 2 is 2, 3, 4, 5, and 6. You select one of these. The AB 38 also says that the buyer and the seller must come to an agreement about who will be responsible to have the property inspected within 1 year. Well, makes sense that the seller is not going to take on the responsibility of getting the property inspected with 1 year. If the seller is going to take on the responsibility of getting the property inspected, he's probably going to have to do it before the close of escrow. But as I just said, there's no requirement for them to do this. So Carr Legal and Walt Klein, yours truly, is recommending you check box 3. The buyer responsibility. There is a local vegetation management ordinance in effect. See, the default doesn't work for us because we do have an ordinance. So we have to check one of the boxes 2 through 6. And we're recommending that the buyer can take responsibility for that. because there is no requirement to have the property inspected as a result of the sale. And then the buyer will comply with the code within 1 year close of escrow. And so box 3 is checked. Now, a couple of things about that. If you represent the buyer and, somebody, got a bootleg copy of this recording from another company, and they said, okay, Walt Klein's recommending 3, I'm going to check 3, and you represent the buyer, your buyer might want to look at the property, and he cannot have a government agency inspect it, but he could have a private party look at the property and give him some advice as to what will it take to bring the property into compliance if he has a question. And again, that's not going to be at all an issue for a condo. It's probably not much of an issue for most tract houses because they're well within the tract. They're not on a canyon like I am. They're not in an area that's a very high fire zone like I am. So, so it may not be a big deal. But if you're buying 4 acres out in Ramona, you might want to have your buyer look into, what will this take? Because the plan is for CAL FIRE within 1 year to inspect all properties that are in high and very high fire zones and then issue notices to bring the property into compliance. So the buyer is going to possibly incur some expense if he's got, quite a bit of land around his house, and that land is not currently in compliance. So that's one thought. The other thought I will tell you, I've had quite a few discussions with the other side, and once they get it, they're fine. It's interesting. I've had 2 discussions of late where the other side, and I can't disagree with them, correctly said, well, wait a minute, before we agree to being the buyer's responsibility, okay, I accept, Walt, we don't have to do it at the point of sale, but if the buyer is ultimately responsible for this, we may not want to take that position. We may want the seller to do it anyway. They have that right. You have the right not to agree. See, this is the paragraph C is actually an addendum to the contract. The civil code requires buyer and seller agree to one of these. And absent an agreement, Carr Legal feels it would probably fall back on the seller, even after close of escrow. So you want one of these boxes checked. We're recommending box 3. A couple boxes don't even apply. But you might get some pushback. So how do you get around that? You provide the FHDS if you're in a high or very high fire zone with your counteroffer filled out completely, because when the buyer accepts the counteroffer, he's accepting you are checking box 3 and saying, look, we're not doing anything. We're going to close in 2 weeks, and buyer, you're going to take care of this within the next year. So highly recommend listing agents provide the FHDS with their counter if an FHDS is required. And we went through what the requirements are. Provide that with your counter, and then you won't get pushback from the buyer early on. The buyer wants the house. You're going to have a harder time amending a contract. The buyer's already locked into the house, and now he doesn't want to agree to this. And you don't want to cancel, and the buyer doesn't want to cancel, but the buyer is going to threaten, okay, I'm going to cancel, because absent an agreement, the buyer has the right to cancel. So, and again, that's, until the FHDS is delivered and the buyer accepts it, they have that right to cancel. So that's, again, why you want to get this out early, and ideally even as a part of forming the contract. Hope that's clear. You got any questions, by all means, reach out to me. And then the FHDS does have some additional information. If in fact you've already got a report, you got to provide where the report's from, how to contact them, and whether you got a final inspection report. Okay, insurance claims. The rest of this class is going to go pretty quickly, so don't panic. We're 2/3 or 1/3 through, and we're 2/3 through the hour. But we'll be okay. So insurance claim disclosures. Civil Code, California Civil Code requires that a seller disclose any insurance claims affecting the property within the past 5 years. I'm not telling anybody in this call something they don't already know. Okay. Now, where do you normally provide that information? Well, you provide it on either the SPQ. Back to those questions, insurance affecting the property in the past 5 years. By the way, that is not a statutory disclosure. Okay, so if you remove your contingencies and then you find out there's an insurance claim, you could have a problem. Okay, so it's in the SPQ, and for properties that are exempt from an SPQ because they're exempt from a TDS, And then it's in the ESD, insurance claims with property in the past 5 years. So again, you want one or the other early in the transaction so that you can address that issue. I would also suggest, buyer's agents should tell their buyer two things when their offer is accepted. Yay, your offer got accepted. Okay, you got to do two things quickly. Get with your lender now and get that loan process started. Get with your insurance agent and get your homeowner's insurance process started. The good news is, relative to insurance, the buyer doesn't pay a nickel. So he calls his insurance agent and tells his, hey, I just bought a house. So he finds an insurance agent. I want a policy, because as a part of that policy being quoted, they're going to do a clue report, and we're going to find out if there's a report or not, even if the seller doesn't remember and checks no. But we find out, oh yeah, 4 years ago, you did file a claim. So you get your insurance, your buyer seeking insurance immediately after the offer is accepted. With the lender, you got to spend some money. You got to pay for an appraisal. You still need to do that immediately. I'm always recommending the buyers make contacting the insurance agent just as important as contacting the lender as far as priority, getting it done, getting on it right away. Okay, now insurance claim disclosures. This is what gets us in trouble. A complete, in quotes, insurance claim disclosure really consists of two sets of documents. And we've had some pretty significant problems because the insurance claim disclosure was incomplete because the agents involved didn't quite understand what I'm about to tell you here. The first sort of set of paperwork, if you will, is the claim itself. It's going to be the insurance company paperwork. It might detail the damage to the property. It's going to talk about how much money the insurance claim is for, and the insurance company is going to pay the seller so much money. It's going to tell you the date of when it happened. It's going to give you some idea of the extent of the damage, what was done to the property by the event, not what was done by some human being, but by water intrusion, the sudden event that caused an insurance claim. Okay. The second set, and this is what's often missing, is any information regarding what did the seller do about the damage? Basically, what repairs did they make? Typically, there are exceptions, but typically insurance company does not repair the house. The insurance company typically has an adjuster go out and determine the damages and then writes a check to the seller. And they, within the insurance contract policy, if the seller doesn't make the appropriate repairs, then their insurance may be invalid for a future claim. So that's the motivation of a seller to go ahead and take that money now and fix the house. And I would argue most sellers do. But here's what happens frequently. The insurance company pays the seller for 10 things, and the seller fixes 4. Because the other 6 he doesn't care about, and he pockets the money. So when you look at just the insurance claim itself, the buyer gets a misconception that this has all been fixed. No, it hasn't. The seller was given money to fix it. Sometimes the sellers are reluctant to share part 2. Why? Because they think somehow they've committed a fraud. They collected money from the insurance company to fix 10 things, and they only fixed 4. I've had sellers, when I figured out where they're coming from, a little bit of emotional intelligence and realizing, okay, this is not a bad person. He just doesn't want to get in trouble. He has no obligation whatsoever to spend any of that money fixing anything, with the exception it could affect his insurance on the home that he has. But he has every right not to fix it. It's his house. He was paid for the damage. He bought a nice house that didn't have damaged drywall, and now he got damaged drywall because of a leak. And if he chooses to live with damaged drywall, he has every right to live that way. He also has every right to be compensated for the loss he suffered because the drywall was damaged. The lay people, the sellers, tend to think they only have a right to that money because they have to spend it to fix it, and so they don't fix it. So I'm kind of giving you a little insight of why this is harder to get from a seller, because the seller thinks that this is somehow sneaky. Very sneaky if you don't tell us. But if you tell us, hey, I didn't do anything. I put all 100 grand in my bank, went on some nice vacations, bought a few toys, and I don't really care about the damage to my house. You know, seller has every right to that. So back to the point here, when you make an insurance claim disclosure, you should provide the paperwork from the insurance company and the paperwork from the seller and any receipts from people who did do repairs, contractors and whatever, who made the repairs. When you're the buyer, you want to look for that. You want to look at the insurance claim itself, and then you want to look at, okay, what did you do? Who did you hire? What did they do? Did you fix everything? Who made those repairs? Very important. Okay, moving on. Affirmative statements and answering buyers' questions. Pretty straightforward. An affirmative statement is any statement that affirms something to be true. Civil code actually says that if an agent makes an affirmative statement to a buyer, the buyer has the right to rely on that as factual. And if in fact it's not factual, the buyer has a cause of action against the agent who made the affirmative statement in error. In other words, it turned out not to be true. It's called constructive fraud. It sounds horrible, but constructive fraud is you made a misstatement. You didn't mean to, but you did, and it's still a misstatement. So affirmative statement. When you say something is so, it better be so. See, it's stated as if it is actually true. That's the law. The law says that whatever you say is an affirmative statement is actually true. The buyer may rely on that. So here's the question you need to ask yourself. When you are providing information to the buyers, are you absolutely sure the information you're providing the buyer is true? How old is the roof? I'll check with the seller. It's 5 years old. The roof is 5 years old. Bingo, you're in trouble. Not if the roof's 5 years old or 4 years old. No one's going to sue you for your roof not being as old as you said. But if the roof is 15 years old, but 5 years ago they did some repairs, when the buyer finds out the roof is 15 or 20 years old, by the way, we've had a couple of claims exactly with that scenario. Buyer finds out the roof isn't what he was told. And here's the bad news. There's written documentation where the agent said, yeah, it's 5 years old. Well, you don't know that's true. You didn't put the roof on. See, that's a mistake. Only make an affirmative statement when you have actual firsthand knowledge that what you are saying is in fact a true statement. See, I can tell you absolutely my roof is 2 years old. Why? Because I put the roof on. I didn't. I hired somebody, but I paid the bill, or my wife paid the bill 2 years ago. But I was out there watching them do it. If I tell somebody my roof is 2 years old, they don't know that. If I were to list my house with an agent, I'm not a licensed agent, pretend, and I list my house and I say my roof is 2 years old, the agent should not be telling the buyer, oh yeah, the roof's 2 years old. Why? Because she didn't have firsthand knowledge. She wasn't at my house when I put the roof on. So if you don't have firsthand actual knowledge of a fact, don't make it as a fact. So when providing information that you are not absolutely certain is in fact true, use qualifiers. I believe, that's a factual statement. I believe it's 2 years old. Why? Because Walt told me it was. See, and you should add, but I'm not certain. According to Walt, it's 2 years old, but I haven't verified that. So qualify your statements unless you know for certain what you're saying is true because you did it. We have an agent, not with us anymore, but he used to do a lot of work on houses for his clients. That was what he did. I mean, he probably got close to violating contract license law, but he was a good guy. He had good handyman and did good quality work. He borrowed my tools sometimes to do the work. I helped him on my neighbor's house. He would do a lot of the work. So he could tell the buyer, yeah, that was replaced last month. Why? Because he was the one that replaced it. But if you're told that was replaced a month ago, according to the seller, that was put there about a month ago. See, you weren't there when it was installed. See, that's the point you want to make. Now, here's a rule of thumb when answering buyers' questions. Name the source of the answer. So the buyer asks you how old the roof is. So you find out from the seller. And so you name the source according to the seller, then state whatever the source provided you. By the way, have that in writing from the source because the seller's going to say, I never told you it's 5 years old. Yeah, you did. No, I didn't. Say, In fact, what happened was in the most recent case, the roof was repaired 5 years ago, but the roof was actually closer to 30 years old. Actually, it was at the end of its life. Uh, so have the seller put in writing the answer to the question. So name the source. According to the seller, the roof is 5 years old, and then deny verification. What does that mean? It means say something like, I have not verified that information. I don't know that it's 5 years old. I haven't verified that. I'm not going to. I don't know how to. Okay. Now, that's if you're the listing agent and you're answering buyer's questions, or you're providing answers to buyer's questions to the buyer's agent. Now, if you're the buyer's agent yourself, you need to add a fourth thing. If you represent the buyer, then you also need to advise the buyer to perform an investigation. If this matter is a concern to you, Mr. Buyer, Ms. Buyer, should investigate this further. We should have the roof inspected by a roofer and have that roofer tell us what his opinion is, what her opinion is of how old the roof is. Okay. Advisories, real quickly. Let me go tell you about these advisories. I'm just going to tell you about them, and a couple of them are real straightforward. In fact, they all are pretty straightforward. One of them is a car form. 3 of them are RE/MAX connection forms found in Agent Hub. Okay, so the first advisory is a preliminary title report advisory. I highly recommend this form. It gives the option for the buyer to tell you, especially with mapped easements, especially our Fallbrook agents use this all the time, because the buyer, the title rep will go out to the property and walk the easements, will map out the easements on the property, sort of a service that some of the title companies do. So this form allows the buyer to declare, I need to talk to a title person about this title report. This advises the title, review the title report carefully. I highly recommend that as an agent, you should click on every link on the title report and look for things that might be of concern to the buyer, and then tell the buyer to do the same thing. And of course, I kind of shudder a little bit when I say might be of concern to the buyer. That's causing you to make an assumption. So anything other than the trust deeds, because the trust deeds are going to get paid off, that doesn't matter. But anything else that's recorded on the property that's going to stay with the property or needs to be addressed as part of the transaction, you should probably review that with the buyer. Have the buyer click on those links themselves, and then you and the buyer discuss it. Okay. Now, the CAR form is the Buyer's Homeowner Association Advisor. This is a very important form. We used to have an in-house form. We used it for years and years and years and years at the Scripps Ranch, Escondido, and Fallbrook offices. I got rid of the form because the CAR form is even better. It's more detailed. My form was a 1-page form. This is 2 pages, and it advises the buyer to review the HOA docs carefully. You, as an agent, should not even receive the HOA docs. You should not even receive them. The escrow should send them directly to the buyer, and they're way too much for you to go through them and read. And then how are you going to determine something that's of a material concern to the buyer? You have no idea what the buyer's pet ambitions are. Just as soon as they buy their own place, they live in a rental now that doesn't allow pets. As soon as they get their own place, they're going to buy, buy a Saint Bernard or an Irish Wolfhound. And somewhere in the rules, it says no dog more than 20 pounds. But you don't even know they're planning on that. So you going through the rules and regs is a mistake. You shouldn't even look at them. I've talked to several attorneys. Here's the good news. That is standard practice. It is standard practice for the agent not to review HOA docs. If you are actually reviewing the HOA docs, you are suddenly bringing liability to yourself. It's sort of like going to Megan's website. Never, 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 ever go to Megan's website. If you've got young girls at home, maybe you do need to go. I don't know. Even young boys, perhaps. But you don't want to go as an agent, on a home you're selling, because now you have to disclose everything you saw there. Why? Because you looked at it. Okay, so if you don't go, there's no standard of practice that a buyer's agent checks Megan's website. So it's the same sort of thing, okay. But this is a very good advisory. Anytime you sell a home with a HOA, ensure that this is part of the transaction. I believe it's on the checklist. So the file checkers, Holly and Lindsay will alert you if you haven't done it. Okay. The mold advisory, we don't recommend it. We require this for all transactions, even if we don't represent the buyer. Why? Because mold is a big, big lawsuit problem. Almost every every other lawsuit some way involves mold. So we want, even if we don't represent the buyer, we want to be able to say in our defense, the buyer did not protect themselves. They were advised about mold and they didn't do anything about it. So this is required in all transactions, pretty straightforward. And then finally, if you are selling raw land, then we have a Remax Connections land purchase advisory. By the way, this is a great objection handler. If the buyer tells you, we're going to build our dream house, and then you got to go traipsing through all the woods and all the brush to find them a lot, and they're having trouble getting financing, and half the lots they find they don't want. And you're thinking, man, I'd just like to sell them a house. I can sell a house. This selling this land is a pain in the neck. You give them this, they're going to say, you know what, maybe we shouldn't be buying land and building on it. We should just buy a house. I've had many agents tell me they actually use this form to gently dissuade a buyer from buying a lot to build their dream home on, because it's a lot more involved than they think. This is a 2-page form, and as you notice, there's no room for a letterhead. You know, I didn't want to make it 3 pages. I wanted to keep it as short as possible, and it lists just about every possible issue a landowner will come up against if they buy a piece of land with the intent on building on it. So be aware of this. It's an agent hub. Okay, tenant occupied properties. Let me see if I can't wrap this up in about 5 minutes. A tenant occupied properties, you want to check the TOP. You want to provide a TOP if when at the point that the contract is executed, there's a tenant in the property. If the tenant's going to get out of the property tomorrow, but we're signing the contract today, I'm including a TOP. Anytime a tenant is in the property, include a TOP. You also check the TOP here on paragraph 4. That's an addendum attached, and that will attach automatically to your RPA. Or if you want to counter, then you don't check this, of course, because it's part of the RPA, but you counter the TOPA back to the buyer. So the TOPA, and I'm not going to go through it in any detail with the exception of the beginning. The default is the tenants are going to stay in the property. So no, this tenant's moving out next week, Walt. Okay. And the buyer wants to buy it vacant because he wants to move in. Okay, fine. We'll check the box. Now, here's the point about the TOP. If the seller cannot get the tenant out, and believe me, some of you know, you've been there, it is not as easy to get tenants out as you think it is. If the tenant's a good person and is willing to move out, good for you, and congratulations, the seller must have treated them well because they're treating the seller well. I'll tell you, I only hear about the problems, so maybe I'm a little jaded, but we've got lots of stories about the tenant won't get out. And so you think the tenant's getting out, you've given the tenant notice to get out, but he's not out yet. You need the TOP, and you can check. No, the buyer wants to buy it vacant. That's fine. You're going to try to get the tenant out. Tenant said they would move out, but if the tenant doesn't move out, the seller's only obligations to the buyer, if he can't get the tenant out, is if the buyer cancels, and he has a right to cancel because you can't get the tenant out, you only pay for his inspections and his appraisal. That's it. Absent a TOP and you sell the home vacant or you sell it buyer occupied, you don't get the tenant out, your client could be liable for thousands, tens of thousands of dollars in damages to a buyer. So do not ever, 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 never, ever sell a property that has a tenant in it. And by the way, the tenant does not have to be a rent-paying individual. It can be a relative. We had a tenant one time that was the girlfriend of the boyfriend. The boyfriend owned the house. He moved out of state. His girlfriend said she would be moving out in a couple of weeks. She did not. And it took us 2 months to get that girl out of there. She's a tenant by consent, by law. Relatives, if they're minors, that's different. But if they're not minors and your nephew's living in the house right now because he's between houses, he's a tenant by consent, and he has all of the rights of a tenant. Anybody living in that house other than the seller, you want a TOPA. All right. So that's paragraph 1, A or B is real critical. And then there are additional terms. They're pretty straightforward. If you have any questions, call me. I think the one thing is that the landlord, the seller, cannot alter the leases or add people to the leases or do anything once he's under contract to sell the property without the buyer's permission. And then the other thing is tenant estoppel certificates. You want those. You want a previous slide talked about all the financial statements about a tenant occupied property, especially if the tenant's going to stay in the property. So that's pretty straightforward. And termination of tenancy. Sometimes you're asked to get the tenant out. What you want to keep in mind is that if you're going to terminate a tenancy, you've got to be aware of the RCJC, because there are certain responsibilities a landlord has to a tenant. There are certain restrictions of putting a tenant out under the Tenant Protection Act, AB 1482, I think. And so the RCJC sort of outlines that. So if you are representing a seller who has a tenant in the property, the first thing you want to find out is, have they delivered to the tenant an RCJC? And if they haven't, then the landlord is not exempt from the Tenant Protection Act. The biggest problem, a landlord who's selling a house, whether they're exempt or not exempt, they have legal grounds to put a tenant out, as long as the tenant's month to month or the lease is ended. Either way, they can put a tenant out. But if they're not exempt, excuse me, from an RCJC, in other words, they are, they're not exempt from the Tenant Protection Act, then they owe the tenant 1 month's relocation expense, 1 month's rent, relocation expense. If they're exempt, they don't owe that. That's important. So the first thing you want to do is provide the RCJC and check that box right there in the middle. This box right here in the middle of the RCJC. This is if you are exempt from the RCJC. And if you have any questions about it, give me a call and I'll walk you through whether or not you're exempt. I would say most landlords are probably exempt if they're mom and pop landlords. Even if they have multiple rental units. If they own the properties under a corporate name, they are not exempt, by the way. So that's something, I've come upon that. That's the most common non-exemption that I've come upon. Okay. And then there are additional exceptions that only apply to a boarder in your house. I can talk about that. And then you have reasons for putting somebody out of a house, even though they didn't do anything wrong. And one of the reasons is that you are taking the home off the market. So, off the rental market, and you're putting it on the sales market. And so you're no longer going to rent it out. So you can put the tenant out if they're month to month with appropriate notices, and you serve them the notice of termination of tenancy. And, you complete paragraph 2 or 3, but not both. 2 is you're not exempt from the TPA. And so you can see, though, that you do have the right to check this box and withdraw the property from the rental market because you're selling it and you want it empty. It's easier to sell when it's empty. It doesn't have a tenant in it, and you have the right to do that. However, if you're not exempt from the TPA, you do have to pay that relocation fee. So that's why that giving the RCJC, if you're exempt, you have to give the tenant a 30-day notice that you are exempt. So most landlords have never given the tenant any notice that, hey, by the way, that new law, that TPA that was passed back in 2019, I'm exempt from that law. If you don't tell the tenant that, you are not exempt. And so you have to tell the tenant that. So you give the tenant the RCJC, check that box in the middle, and then you wait 30 days, and then you give the tenant a notice to get out. Now, if you're not exempt from the TPA, it doesn't matter because you're going to be paying that relocation expense. But if you are exempt from the TPA, you check that box, and then you have the right to a 30, a 60, or a 90-day notice, depending on certain circumstances, including a 30-day notice if all of the following are true, which is contained in paragraph 3D. And then finally, the last page is service of the notice. And here's the point I want to make. Emailing is not legal service. You have to mail it certified, or you have to hand deliver it. But emailing it doesn't work. So that's the notice. And that, folks, wraps up the seminar for today. Hope it gave you some information. And Lindsay, we'll take a couple minutes and answer a couple of questions if we have any.
Sure, yeah. So Mary says that she keeps getting the AVID late. Isn't that part of the TDS?
It may or may not be. That's a great question, by the way. If you're getting the AVID late and they checked on the TDS, see attached AVID, then it is part of the TDS. Now, an agent is required to make a visual inspection, both the listing and the buyer's agent, and report to the buyer what the results are. An agent could simply write on the TDS, and again, they should never write, although some still do it, recommend buyer get physical inspection. That just proves to the courts you didn't do an inspection, because this is not an advisory blank. This is a, what did you see when you looked at the house? So some agents write, see some drywall cracks. I see concrete cracks in the driveway. I see some drywall cracks in the house, and the carpet looks to be aged. If they wrote that on the TDS, they did their inspection and they delivered the TDS. If they check the AVID is attached, the TDS is not delivered till the AVID is delivered. Now, that's only for the listing agent. The buyer's agent must also do a visual inspection. You can also do an AVID. You should, if you're the buyer's agent, but you can't defeat the delivery of the TDS because you, as the buyer's agent, are going to wait before you do your agent's visual inspection to provide the AVID. Hope that answers the question.
Barbara Dudek asks, I think this is in regards to the FHDS. Many sellers don't know how to respond to many of these questions.
Right.
That is where the NHD comes in. I wonder if CAR should visit these questions.
Walt, it's Barbara. No, thank you, but I should have been more specific. That's basically some of the questions on the SPQ. I mean, are you in a high fire hazard area? Are you next to hazardous waste? I mean, so many sellers have no idea what those answers are.
Let me help you out, Barbara, because you're making what's often a common mistake, if I may say that. They're not asking, are they next to a hazardous toxic dump? They're saying, are you aware that you're next? See, so a seller cannot not know what they're aware of. So if they don't know, the answer is no, I'm not aware. You could be next door to a sinkhole full of radioactive waste that they snuck out of San Onofre. But if you don't know it, you can say no, because I'm not aware of it.
Okay. Thanks so much.
Yeah. Okay. Good to see you, Barb. Thank you.
You always.
Libby asks, do you suggest delivering the TDS and the SPQ with the response to the buyer's offer?
You could do that. The salesman in me says, let's get them committed to the house and then deliver the TDS and SPQ within the 7 days, and do it within 2 or 3 days. Because once they get the house, they may be slightly more committed. Now, the exception to that rule would be you have a foundation crack and it's pretty severe. You probably want to put that in the MLS. You certainly want to disclose that early, because you don't want to be in escrow. If the delivery of the TDS is going to precipitate a typical buyer to cancel, then yeah, give the TDS with the offer. But if the delivery of TDS is more, I hate this word, but more normal, if you will, just typical wear and tear, a couple of problems, yes, but doesn't keep us from enjoying the house. My belief is, get the buyer committed to the deal, get an escrow, and then give it to the buyer within a day or two.
But if you're giving, Walt, if you're giving the FHDS, and why not? If it's an innocent TDS, just go ahead and give it to them. Because my question is, if accepting the offer, the counter offer, they're accepting the FHDS, are they also accepting the TDS and the SPQ?
No.
No. Okay. Never mind then.
Right. The difference is the FHDS paragraph 3 is an addendum to the contract. The buyer has to agree to what's on there.
Yeah.
So that's why I was saying earlier, 2 months ago, every buyer would agree to, yeah, we'll give you another extra $10,000. Let me buy the house. I'm getting a few people now because the buyer's market is coming back a little bit. And I've had a few buyers agents, especially the manager, point out to me, well, my buyer may not agree to this. My buyer may say, nope, we don't care what because once I convince them what the law is, which I don't have any trouble doing, really, I can do that. Most of them say, oh, okay. A couple of them had said, okay, but we may not agree anyway. We may still want the inspection because the buyer, it's going to be his choice. Well, so that's the difference. The TDS is not a contractual addendum.
Gotcha. Thanks.
Of course.
Gene Wilson wants to know, what about Riverside County for FHDS number 3A?
Well, 3A, yes, Riverside County has a vegetation management ordinance as well. So 3A would be checked is. But Riverside County, you can still check in 3C, box 3. You can still check that because there's no local point of sale ordinance anywhere in Southern California. In fact, throughout the state, the only place is Truckee and what's the other place? What do they call it? I'll tell you in a second. You're not selling houses there anyway, but Contra Costa, which I believe is where Paradise is located. They have point of sale requirements. And recently, Big Bear passed a point of sale inspection requirement. So,
Bibiana Rico, I think this is in regards to the FHDS. If the seller doesn't know any of the answers to these questions, can they leave them blank?
No, a blank form is an undelivered, uncompleted form. Again, you're making, and it's a common mistake. You have to remind the buyer of this, or the seller, and actually have to tell the buyer this too. By the way, these aren't statements of fact. This is the seller's knowledge of what the facts are. So the seller isn't saying, I don't have a flammable roof. He's saying, I don't know if I have a flammable roof or not. So you can't be not aware of what you're aware of. So if you don't know, it's probably no. See, no is a default answer most of the time when the seller doesn't know. Do you have, do you have any problems with your plumbing? I don't know. I don't think so. I'm not aware of any. So you say no. Doesn't mean you don't have any problem with your plumbing. It says you're not aware of any.
Jeff asks, so if the seller provides the FHDS with the counteroffer, should it be provided with the box 3 checked?
Yes, box 3. Exactly. Yeah. One of those boxes had to be checked. And if you read them all, let me tell you, I read them multiple times. You don't want to check any other box.
Okay, Susan asks, regarding the FHDS, if the property is in a community where the HOA takes care of common areas, would the HOA be responsible for the inspection/compliance?
They probably would be. That's a fact. You still have to provide the FHDS, and you can get away with box 3 much easier because I've actually had that. I made that argument to the buyer's agent. Look, this is a condo. The buyer's not going to incur any costs in a year either. The condo association may, but the buyer's not. And so, yeah, you check that paragraph 3 and you do provide it.
Brenda says some escrows have been copying her on the HOA doc emails to the buyers. So the buyer sees that Brenda has a copy and asks her to answer many questions. I tell them to call the HOA, but they always want answers from me.
All right. First thing I tell you, Brenda, is to call your escrow company and tell them not to send them to you. Because here's the problem: when you receive them, you have what's known as constructive knowledge. See, if I never looked at the HOA documents, I have no idea what's in them. And here's the good news. I can get away with that because that's customary practice. If I put 10 agents on a witness stand during a lawsuit, I can get at least 8 of them to say, no, agents do not read all of the HOA docs. I mean, there's no way they could. That's going to be the standard of care that you're going to be judged by. So you can get away with that. You can't get away with that with a TDS because, yeah, you do get the TDS because you're the one that delivers it to the buyer. So you do have to look at the TDS. So we have agents that, same with the physical inspection. It is customary that the physical inspection be given to the buyer's agent so the buyer's agent can prepare a repair request. So you have knowledge of what's in there. And so you do have to sort of talk about it with the buyer. But with the HOA docs, it's better if you don't receive them. We can get away with that if we get sued. And you don't want to receive them because if there is something in there that you should have told the buyer about, the fact that you received them opens you to a little bit of liability. And so, one-on-one, I can help you with some dialogue to help the buyer. If you gotta get the buyer to believe it's in their best interest. By the way, it is to be asking the HOA these questions, not you. And so I can help you with some dialogue there. You're pretty sharp. I should not say pretty, but I mean, you are pretty too, but I mean, that's another seminar.
Thanks, Walt. I appreciate that.
Well, it's interesting. I don't want to get the weeds there. I want to wrap up, but there's an interesting difference in the use of the word pretty by males and females. If I say you're pretty smart, I think I'm complimenting you. But women believe, but when you put pretty in front of anything other than looks, it's derogatory. So you're pretty smart, but you're not really smart. That's how women look at it.
Go ahead, say it.
I think that depends on how old that woman is, Walt.
And
I'll take pretty with anything at this point.
Psychology. So I've had a few people call me out on it when I said, well, you're pretty smart. They think, well, thanks a lot. And when a guy says it, he means you are very smart. But when a woman hears you're pretty smart, they think that's a qualifier that diminishes, what we.
The next class on sexual discrimination.
No, not so much sexual discrimination as it is psychology and the misunderstanding of words we use.
You're digging yourself deeper, Walt. Let it go.
We'll move on. Barbara Dudek wants to know about squatters that have come into your listing.
Well, I mean, that can be problematic. If they don't have legal right to be there, you may be able to call the county authorities or the city authorities to see if they can move them out. That's going to be a problem. I think that's a one-on-one situation. So, but if squatters are into your property, that could be problematic for you.
Thank you. We're hoping to close on Friday, and I think we've got her out now, but we'll see.
My goodness. Libby wants to know, is an ADU tenant considered within your house for exemption?
No, an ADU is not, because part of the within your house is if you share a bathroom or a kitchen. So ADU have their own bathroom, their own kitchen, so they're a unique tenancy.
Jeff asks, if you have not issued the RCJC and want to issue a 60-day, you are actually bound by a 90-day time frame. Is that true?
No, not necessarily. The problem, you can still give a 60-day notice. The problem without giving an RCJC is you're not exempt from having to pay 1 month's relocation expense. So the RCJC doesn't so much give you shorter time periods for notices as much as it protects the landlord from having to give the tenant the equivalent of the last month's rent free or in cash.
Right. So just a real quick one, Walt. So if this place is in Del Mar, their rent is $8,500 a month, but they don't have an RCJC. So essentially, to be exempt from that, if they want to deliver just a regular 60-day, they're not exempt from having to pay them, correct? If they haven't done the RCJC.
So they may be able to put them out, but they have to pay them $8,500. So it's worth waiting a month to give them the RCJC before you give them the notice.
Right. So otherwise, if they deliver the RCJC, then they wait the full 30 days, then they give the 60, because they would still have to give the 60, right? To actually have that exemption be correct.
Exactly correct. It turns into a 90-day thing. And a lot of sellers have a problem with that. But in your case, they shouldn't.
Yeah, not for $8,500.
Exactly.
Yeah. Thank you.
Great question.
Sissy says, if the sellers are not in a high fire zone per the NHD, is it okay to not provide the FHDS?
In a high or very high, then you don't do an NHD, FHDS, right?
Okay.
So if they're not in a high or very high fire zone, then you're exempt. You're not even covered by the law. So yes, the answer to that question is yes.
Last but not least, Dave Zeman says, well, you're pretty smart.
Well, see, coming from Dave, I think that means I'm smart. Now, if a lady said that, I would have to say, well, she might be qualifying how smart I am. That to put a tap on that, that's the word pretty. That's the interesting thing to me anyway. In psychology, the word pretty is a positive qualifier when men use it. It's a negative qualifier when women use it, because women believe that if we say you're pretty smart, they think we're diminishing their smartness. And men don't. Men think if someone says to me, well, you're pretty smart, I'm going to walk away with my chest out. Oh, right. Good for you. And that's universal. I stumbled upon that years and years and years ago. And I'm so fascinated by this. National audiences, I would take surveys, and it is so true. It's amazing. And some of you that might be on this call, we've had one-on-one calls where we've talked about it, but yeah, that's a different seminar, the use of work.
That's it.
Okay, folks, I want to thank you. We ran long with the Q&A. It was great to have you all on the class. I'm thrilled that you take the time out of your day to sit in on these sessions. Lindsay will put a recording up. I will get her the PowerPoint, so she has that. You have the handout. And if you need anything, call me. I'm happy to help. Take
Thanks,
care.
Thank
Walt.
you.
Bye, Walt.
Bye-bye.